So we're still in the due diligence period. Why can't I terminate as the seller? I have another offer I want to accept. Hi, everybody. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America, here with a brief video tip about the due diligence period in a real estate purchase and sale agreement, at least here in Georgia. So the question has come up about the due diligence period. A seller wants to terminate during a due diligence period. Are they allowed to do so? Well, the contractual answer is no. A due diligence period is only a buyer's right to terminate, not a seller's right to terminate. But stay tuned, and as an agent, we'll talk through how you work your buyers and sellers through a situation where a seller does want to terminate. But first, let's talk about the contract and see what it says about a due diligence period. So, generally speaking, once a buyer and seller go under contract, there are very few ways that a seller may terminate without being in default. There are a lot of contingencies, and the majority of the contractual contingencies are buyer contingencies, where a buyer has the option to terminate without penalty or losing their earnest money. So let's first look at the GAR, Georgia Association of Realtors contract, and see what it says. So in the GAR contract, paragraph A8, that is where the buyer and the seller negotiate for the time frame for a due diligence period. It says property is being sold subject to a due diligence period of fill in the blank number of days from the binding agreement date. Then when you go to the corresponding paragraph and what that all means, paragraph B8, subparagraph F of the Georgia Association of Realtors Purchase and Sale Agreement F201, it states, if the property is being sold subject to a due diligence period, then A, this agreement shall be an option contract, during which time the buyer shall have the option for any reason or for no reason to terminate this agreement upon notice to the seller given prior to the expiration of the due diligence period, in which case a buyer shall be entitled to a return of the buyer's earnest money without penalty. And then it goes on to say, B, a buyer may, during the due diligence period, amend the contract by asking the seller to address certain concerns. And C, if the buyer has not terminated this agreement as set forth above, buyer shall accept the property in as-is condition, subject to any amendment to this agreement to address concerns agreed to by the parties. And just so you know, in the RE forms, sometimes referred to as the FMLS forms, the same buyer side contingency is agreed to. It's in paragraph 6 of the RE purchase and sale agreement contingencies. And in fact, in that contract package, they actually call it, instead of a due diligence period, they refer to it as the buyer's general right to terminate. Same thing, it expires so many days from binding agreement date. And then in the RE forms, in the standard terms, the corresponding paragraph 6.1, where it goes through what that is, the buyer's general right to terminate. It does state that subject to any expiration date expressed in the contract, the buyer's general right to terminate is defined as the seller's grant to the buyer of the right to terminate the contract by delivering written notice to the seller and receiving full refund of earnest money. And it goes on to say, just like the GAR contract, buyer shall also have the right, but not the obligation, prior to the expiration of this contingency, to propose to seller an amendment to the contract to address any concerns, so forth and so on. Seller doesn't have to accept it. So, couple of things. Number one, you buyer's agents, that is a drop dead time frame. What do you mean by that, Dana? What I mean by that is, if the buyer has an amendment to the seller to address some concerns, and The seller has not responded. An open amendment to a seller does not extend the buyer's due diligence period. If the buyer is going to terminate, if it is what I call a make it or break it issue, property needs a new roof, major structural foundation issue, something like that, that the seller or the buyer doesn't know at this point if the seller is going to address or not address, then the buyer either needs to agree to go through with the contract. And if you haven't heard from the seller, the buyer is taking the property as is, or the buyer needs to send notice of termination to the seller prior to the expiration of that due diligence time frame in order to not lose their earnest money. So again, an open amendment to the seller does not extend a buyer's due diligence period. You listing agents, however, this is only a buyer's right to terminate. This is not an option for the seller to terminate. What an option means is it creates a due diligence period, creates what I like to say in classes as a mini option contract within the broader context of the entire purchase and sale agreement. In other words, the rest of the terms of the purchase and sale agreement don't really kick in until after this due diligence period has expired. So it's a mini option for the buyer to terminate or go through with it. I've done all sorts of videos on due diligence, and I will just check the playlist for due diligence. But so a seller doesn't have the contractual right to terminate during the buyer's due diligence period. If they do, then the seller would be in default. If the seller defaults in the GAR and the RE forms contract, it does state that the buyer if the seller defaults, the buyer has the right to either get their earnest money back and go on and find another property, or sue the seller for specific performance. The earnest money stays in the deal. It goes to court, legal fees, court costs, everything else, and a judge decides if the seller is required to go through with the contract or not. This can be a lot of money and take a lot of time. So if a seller wants to terminate after going under contract, there are negotiations between a buyer and a seller that would need to take place. And it could be, especially if we're talking about a seller terminating during a buyer's due diligence period, you have to remember that's pretty early on after the parties have gone under contract. So it might be in a buyer's best interest to negotiate with the seller to terminate, get their earnest money back before they spend money on inspections or appraisals or make any other life plans and go find another house. Or if they really want that house, again, they might have to go hire an attorney and find out what's involved in pursuing the seller for specific performance. How long is that going to take? How much is that going to cost? Where are they going to live in the meantime? So forth and so on. But again, if a seller does want to terminate during a buyer's due diligence period, if they do, they would be in default of the contract. Because it's early on, this is an opportunity for a buyer and seller to negotiate through a mutual termination. And you agents, I suggest you would look at a mutual termination agreement rather than a unilateral termination agreement to work through those negotiations. I hope this contract tip helped you out. Please comment below your experience with this and any other contract tips you would like for me to address. Thank you so much for watching. I appreciate your time. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and dedication. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.